Hi, I'm Gretchen with the law offices of Gretchen McCord, where we work with businesses to help them address whatever legal issues may arise as they are establishing, growing, and building their businesses. One area that we assist our clients with is trademark. So right now I want to spend a couple of minutes explaining how you register a trademark and why you might want to register your trademark in the first place. So first of all, let's remember that a trademark is a brand. Anything you're using as a brand is a trademark. So why might you want to register your trademark? The simple answer is that it increases the value of your brand. A registration will give you presumptive nationwide rights, if we're talking about a federal registration, to use your mark across the USA. It will provide evidence of your ownership of that trademark and your rights in that trademark. And it also provides different types of enhanced enforcement rights. It makes it easier for you to, or gives you a stronger tool to enforce your trademark rights. So how do you register your trademark? We always strongly advise beginning with a trademark risk assessment. The law does not require this, but it is definitely the starting point. If the risk assessment finds no significant risk to registering your trademark, you would work with us to help prepare and file an application, or to prepare and file an application, which the trademark office will then examine. So they will look for both minor issues and major substantial issues. Just because you file an application doesn't mean you're necessarily going to get your registration. But once the trademark office has examined the application and either we've addressed any problems that they have with it, or they don't have any problems to start with, then you will eventually, or ultimately, I say eventually because it is a long process or long time, you will ultimately get your registration certificate, so long as you're actually offering all the products that you claim in your application. So a lot of our clients ask, should I really have a risk assessment done? And we say, absolutely yes, because it is entirely possible, and it happens all the time, to infringe somebody else's trademark, even though your mark doesn't exactly match theirs. If it's close enough, it can be a problem. In addition, trademark rights accrue by virtue of using the trademark, regardless of whether it's registered or not. So looking in the trademark office database is not enough. You need to look for uses of unregistered trademarks as well. And in the end, the bottom line is you can really save a lot, and we've seen this many times, a lot of time and expense and associated energy by having that risk assessment done up front to avoid problems, identify any problems that exist early on, so that you can decide whether you want to go forward with that trademark or not. Application requirements. What do you need for an application? You need the final version of your trademark. You need a description, and we'll work with you to come up with this, a description of the goods and services that you're going to offer under your trademark. Those will be broken into basically categories, but they're called classes. It's a classification system. And the number of categories or classes determines what the ultimate cost of your registration will be. And you need to be using your trademark in interstate commerce, which means you need to be offering all of the goods and services you claim in the application under that brand or that trademark. So after an application is filed, as I mentioned, the trademark office will examine it for both minor and major issues. If they find something that they don't like, they will issue what's called an office action, just basically describing the problem. And we'll have 3 months to 6 months to respond to that, make any corrections or persuade them, argue with them to convince them that they're wrong. Once your application is approved, assuming it is, it will be published, which means that the trademark office is basically putting the public on notice that you intend to register this mark. So if someone thinks that they have rights that will be infringed, they can oppose your application. That usually doesn't happen, especially if we have done the risk assessment first, because we would have identified anything problematic beforehand. So assuming there are no oppositions, if you're already offering all the goods that you claim in your application, then your application will proceed to registration. If not, then you will be given a 6-month deadline to actually start using the trademark, to start offering all those products. But you can extend that deadline by an additional 6 months up to 5 times. Basically, that's it. We have additional information on other trademark topics, as well as other legal topics besides trademark on our website. And always feel free to reach out to us with any questions and to let us know how we can help you make your business successful. Thanks a bunch.